certainly got a cast of thousands.
My lady,
yes, Ms. Briggs.
my lord, in this matter I appear on behalf of the appellant in the first appeal, Reed J, with my lord junior, Miss Andrews. My lady, all parties are represented. Shall I proceed to introduce some advocates?
Probably, actually. We have got the chart.
Yes.
There are some... But I'd quite like to just make sure I know who's actually here as opposed to...
Yes, my lady.
Involved in the case but not present. I've seen Mr. Bowen there.
Very well. My learned friend, Mr. Bow of King's Counsel, appears on behalf of the respondent in Reed J with his junior, Mr. Wilson, and they are accompanied by solicitor from Lloydsworthy King. The first intervener in Reed J, the Secretary of State for the Ministry of Justice, is represented by Ms. Clements of King's Counsel, who is with her junior, Mr. Lang. The second...
Sorry, just let me... Yes, thank you, Mr. Lang.
The second intervener, reunite.
Yes, Mr. Gratian.
Mr. Gratian and Mr. Powell, with their solicitor from Mills and Reeves.
Yes.
In the second appeal, MSKB, the appellant is represented by Mr. Montaz of King's Counsel, with Dr. Gatland, his junior. The respondent, local authority, represented by Mr. Norton of King's Counsel, with Mr. Paisley and Ms. Corporate Stern. The respondent children, in that case, are represented by Mr. Maynard.
Yes, Mr. Rowley, otherwise engaged.
Yes, and the respondent mother in that case has this morning filed a position statement through leading counsel Miss Ancliffe and Mr. Forward. They have indicated in that position statement that they are not attending. That was received shortly before we came into court, and a hard copy has been printed out and made available to you, my lady.
It's not that they are no longer intending to be involved, they simply are not here today. We'll endeavour to attend that part of it. Right, thank you.
In the case of Reed,
yes.
The first appellant, F2, is represented by Mr. Malcolm of King's Counsel,
yes.
Williams Whelan, accompanied by a solicitor from Judge Priestley.
Yep.
Second appellant, Child, is represented by Mr. Bagchi of King's
yes,
Counsel, his junior, Miss Hudson,
yep.
Accompanied by solicitor from GT Stewart. The respondent mother is represented by Ms. McKenna of King's Counsel, with her juniors, Ms. Wiseman and Mr. Landman.
Yes.
And the respondent father, F1, represented by Ms. Paisley of King's Counsel, with her juniors, Ms. Kawere Nolimu and Miss Ellsworth, and their solicitors from Charles Russell speaking.
Yes, well, welcome everyone, and thank you all for coming. I think it's going to be a worthwhile outing for everyone, certainly for us as well. I think the first thing we need to know is we've got to bag the enormous court for the final.
Yes. We'd be very grateful. My lady, just in terms of the documents that we hope that you have,
yes.
There is a composite core bundle which includes the key documents that have been filed thus far in all three appeals.
Yep. Now, so just checking, so far in that core bundle, I've got at C, grounds for appeal and skeletons on J. So that's just skeleton arguments. And then in the judgment, I haven't yet got the judgment in re-em. That's one of the things we need to...
So last night we were told that that has been uploaded to the National Archives, and there should be a hard copy version available for you, my lady, my lord. I see that it perhaps is.
No. Okay.
Ms. Corporate Stern, some hard copy.
Well, we can come to that in a moment.
Yes. So you should have case-specific bundles for each of the parties.
We haven't at the moment. We've got a case-specific bundle for Reed J,
yes,
but not for anything else. But I'm not unduly worried about that for the
Very
purposes
good.
of our directions hearing today.
Okay.
So we've got yours,
yes.
but we haven't got anyone else's. Should we have had some others?
No, lady, I'm sorry, we thought we'd consider the extent to which...
I agree. No criticism at all. We
Thank you very much.
We really didn't need them.
Thank you.
At this stage, I don't think.
then the position statement for the mother and the MSKB is the only additional document that you should have, which it appears you do have.
Yes, so we need to add that into our position statements.
My lady, all parties have been made aware that this matter is being live streamed.
Yes.
It may be the case that reference may need to be made to confidential matters during the course of case management. I flag that at this stage, perhaps not. That
Well, I
doesn't
mean,
concern-
anonymisation is one thing, but confidential matters are often referred to in open court in the Court of Appeal.
Yes.
Protection of identity, which we will achieve.
Yes, it relates specifically to the case management and the time estimates, which seem to be dealt with to everybody's agreement, I expect, in the draft order that we've helpfully received.
Right. Okay. How do you want to deal with matters then?
There are two matters on which it may assist there to be an update. The first is that there has been an application for an intervention by the International Centre for Family Law Policy and Practice.
Yes.
Which
we're aware of, and I think I've noted down in my note for discussion.
yes, certainly for our part, we have no difficulty with anonymised documents being disclosed if decisions have been made as to whether or not an application for intervention is made.
Yes. So just
Can
for
I be very boring? My hearing is not very good, and you've got some unfair competition. Could you just crank up the volume a bit?
I shall, my lord.
That's fine.
Thank you.
I just want to ask everyone about that. My normal routine, I think some of you will know how I do this, but my normal routine is on an application for intervention is that without having to pay a fee and file formal notice, I agree to the disclosure to allow potential interveners to consider.
Yes.
And if they decide they want to apply, they then have to file a formal application and pay a fee.
Yes.
And then people have an opportunity to comment once the skeleton argument in support of their application is made. Now, we haven't got a lot of time in this case, simply because of the vacation coming up. I don't know at the moment what they think they could add to Reunite, given their international status. But it would be helpful, I think, if just a preliminary view. We will allow the disclosure, we'll see what they have to say, but it would be helpful to me, and I think probably His Lordship also, if you just gave us a flavour of whether you think, from your knowledge of that particular very worthy charity, whether you think in this case they would add anything over and above what Reunite have to say about potential international impact of the removal of parental responsibility.
Yes. Well, my lady, for our part, we don't see that there is much that could be added.
Now, I'm seeing shaking heads along the bench. Yes?
We agree.
Right. I will, of course, we will, of course, consider the application for intervention when it comes. If we think that it raises anything in particular that looks different, then we'll come back to you all, and I'll warn you now, it'll be a very tight time scale for you to add a comment. Otherwise, we will, if everyone is content, we will simply deal with that. Yep, everyone happy with that? Yep.
My lady, subject to your approval, it would seem best perhaps to deal with the proposed directions that have been provided to us for discussion, and to take those in turn.
Yes.
Dealing with the issues that you identified in your order of the 1st of July.
Yes, I hope that was more helpful than irritating.
Very much so, my lady, helpful.
Right.
In respect of the Re-J appeal,
Yes.
we really take no issue with any of these directions. There are a couple of matters that I might highlight. Firstly, in respect of paragraph 4.
Just give me a moment, please. You do realise, as your lead, you're going to be the lucky person that has, with your junior, that has carriage of the order that follows on from today, don't you?
I do.
Sorry, Miss Bone.
One of the particular reasons why this is so helpful.
Okay.
And so at paragraph 4, in respect of joining of the current interveners
Yes.
to the other appeals, we would simply add, in relation to the common issues of law.
Yeah.
My lady, there's been quite the melee outside of court, so we've not been able to arrive at a suitable timetable for the insert date parts of this first part of the order, but we anticipate we will be able to do that by email.
Fine.
Following this hearing, subject to your approval.
Yes, well, I think obviously they're only involved so far as the common issues are involved.
Yes. Moving then to the second part of the order, issues and skeletons.
Yep.
Dealing with paragraph 8, with the opportunity for us, again, to try to agree the common issues.
Yes, without sounding like a headmistress, I was disappointed that not only was there no attempt to come up with any common issues despite my earlier direction, but I had, even within single cases, 3 different suggestions as to what the common issues should be. I mean, it really should be quite straightforward to work this out. We know where we're going, we know what matters in this case.
Yes.
And if it's not done, then my lord and I will simply have to do it, which, really we should not have to, because after all, it's your appeals.
My lady, yes. In the position statements that have been filed shortly before this hearing, there are a number of different ways of phrasing the issues, some of which are attractive to some of us and which might be helpfully added to a composite list of issues, because we realise that on the composite bundle as you presently have it, those issues appear at different points in the bundle. It's difficult to see exactly what everybody is saying. Would your ladyship be assisted by a single list of issues, even if that were not to be agreed?
Absolutely, that's how we're going to run this appeal. There's going to be a single list of issues. Your skeleton arguments will deal with that single list of issue in the same order as the issues.
Yes. At this stage, where we have, for example, 2 competing lists of issues that are not agreed.
Well, then send them to us and we'll
very well
cast the deciding vote.
I think the message is try again.
Yeah.
Try harder.
Yes.
And if there's any residual difficulty, then we will make a decision.
Yes.
I mean, perhaps it would be helpful if you give us a single document, and then in the way that you would do in an order where you were struggling to agree an order, and then you can just on the single document, whether colours or whatever,
Yes.
you just show us where the areas of disagreement are.
Yes.
But that you've essentially got a structure
Yes.
for us, and then we're very happy to do that. What we're not happy to do is to start with a blank sheet of paper and strip out all 9, 10, 11 position statements to try
Yes.
and work out where people want us to go.
As something of a stranger in this jurisdiction, the idea is, which is my lady's idea and also my idea, our idea, is that the list of issues should be structured in such a way that, first of all, everybody will be able to approach their submissions by the same route, by the same way, so that we can cross-refer and so on and so forth. And that will lay the ground for our judgment. So
Yes.
this is absolutely critical document.
And it's critical for all of you as well, because it'll give you each of you a roadmap.
Yes. So, my lady, we'll produce that composite document.
Thank you.
By 4 p.m. on the 22nd of July.
I know it's not easy. I know there's a lot of you to do it. I mean, it's entirely a matter of you how you arrange it, but you may wish to nominate, a limited number of you from each team to try and work it through, and then filter it out to the rest of the team to approve, rather than absolutely everybody having a go at it. It's the worst part of drafting by committee, isn't it?
Yes, it's been exactly the difficulty, but we will try again. We will try.
Thank you. I'm
as
very
directed. Over the page then to the next point, which is the filing of skeleton arguments.
Yes.
At paragraph 13. You'll have seen that the parties were able to agree a timetable for sequential filing of those skeleton arguments. Is that acceptable to your ladyship and lordship?
We didn't put those in because we thought that once you've got the shape of the whole directions order and programme, that you might all want to tweak those dates. I mean, if those are the dates you've agreed and you can stick to them, that's excellent. But I don't feel wedded to them at the moment.
I mean, you could take the dates which you've agreed, and we could give liberty to the parties to adjust by up to 24 hours without referring that to the court. Would you be content with that?
Yes. just, so the dates, wasn't it? Well, the dates were appellants 19th September, respondents 10th of October, interveners 31st of October. Yeah, so we haven't got a huge amount of slack there, but that's fine.
No.
But yeah,
Yes.
I think that's a good idea.
Moving down then to the hearing.
Yes.
On behalf of REJ, just looking at paragraphs 16 and 17,
Yes.
we have days 1 and 2 for submissions regarding the common issues, and days 3 and 4 for the welfare matters. We don't consider in REJ that we need attend for days 3 and 4 because we don't have any distinct welfare issues.
Fine. So that's So that would take us back to a 3-day time estimate. But I will hear Ms. Markham on that in due course.
And that.
So just so that we've got, could you, when the order is being drafted, just have it recorded on the face of the order? That's not to tie you down in any way, but just so again, of course, don't forget the president who is sitting on this won't have been here, so that the directions order is going to be a very important document for him. So
yes,
for his early pre-reading and having on the face of the order there's no welfare issues as far as Jay is concerned.
Yes.
Is useful.
There is no other issue that we would wish to clarify with the court and would like to deal with on behalf of the REJ appeal, I think.
Right. Can I just, I dreamt up a few more after I'd finished typing.
Yes.
Sorry. Can I just mention, someone, I've forgotten who, in one of their position stations, mentioned that there was another case finding their way through the system. I think that's now landed on my desk, in fact, for consideration of permission. At the moment, my clear view is that we've got enough cases to consider, and that I've no idea whether I'll give permission. I haven't read it yet. If I gave permission, I don't know whether I will or not. I think it would simply be to stay till after this case. So that's that. Yes, you better have a provision for at least an advocates meeting. We're not going to have another oral hearing. It's simply not practical. Some people, certainly in REM, not sure about anyone else, wouldn't be J, maybe P, need some transcripts of evidence. So
yes,
can we make sure that that's in the directions hearing? I've already been told the judgment in REM is nearly ready. And I'll talk to Ms. Markham about simultaneous transcription in due course.
yes.
So those are, did you have any others?
No, only you working in the repetition.
Oh, yes. Yes. I mean, they're difficult to run these, aren't they, when you've got a lot of common ground and, you will be the lead and so on, and you'll have to bear in mind when you're fixing the timetable, just what is practical. We will not want a load of repetition.
No.
So you're going to have to agree between you how you're doing it. Once you've got your common issues, people will have a very clear idea where they're going.
Yes.
We're allowing 2 days for the common issues, but really we think you ought to probably be timetabling to a day and a half, because we think if there's not a load of repetition, and we of course will have done extensive pre-reading, that probably should cover it.
Yes.
But we're going to allow the 2 days.
Yes.
And so we won't start the welfare hearings until the following morning, so that people can regroup and arrange if their lay clients haven't wanted to come to the common issues for their lay clients to either attend in some form or another for the welfare aspects of the case. But so the firm message from both of us is we're not looking to have it the same thing put 15 different ways,
No.
and we think you can probably manage in a day and a half.
Yes.
Is that the message, Lord?
Spot on.
I'm grateful. There has already been some liaisons between the appellants to ensure that you're not going to have, we hope, any sort of repetition in the Scouts documents. and we will continue to liaise.
And I can remember enough about sitting where you are to know that it can be quite tricky, because you would have put things in a slightly different way and you would have done it a bit more or a bit less or a bit something. But, you know, you'll just have to trust us to get the message.
Melody, anything further from you?
No, thank you very much. That's really very useful. Ms. Briggs. Now, who have we got next? So, Mr. Bow.
Yes, my lady. As you're aware, we act on behalf of the respondent in the first appeal, REJ, myself and Mr. Wilson. I was part of the melee outside the court, so I've already raised.
Voice up.
Sorry, I've already raised all of those issues that have been mentioned by my learned friend on behalf of us. So I don't have anything to add to the draft order that hasn't already been mentioned.
Lovely, thank you very much. Ms. Clement.
My lady, yes. The only additional point from the Secretary of State's perspective is it is not clear to us from the skeletons that we've seen how exactly the parties intend to rely upon Article 8. There's reference to it in various skeleton arguments, but not through the prism of either a Section 3 argument or a Section 6 argument. And it would be very helpful to us if that could be clarified, because if anyone is saying that the legislation per se is incompatible with Article 8, then there are various procedural steps that have to be taken. I don't think anyone is saying that, but it is not clear how, absent that, Article 8 is being deployed.
Right.
Because, of course, the normal approach would be, what is the domestic law interpretation of the provisions? Does that breach Article 8? If it does, how can Section 3 of the Human Rights Act be deployed?
Yes.
And then the ultimate fallback.
Yes.
But no one has put the case in that way. Or certainly we haven't seen it in that way. So I think it would be helpful if that could be clarified
Yes.
and addressed.
That's right.
I think people are not in a position finally to commit themselves. So it's got to be clear and so.
Thank you. Yeah, well, I think that's we think that's an important point. I don't suppose you've had any opportunity to discuss between yourselves quite how you are approaching that. Would be the sensible thing be to include in the directions the time limit by which everybody has to commit themselves one way or another?
That would be very helpful, my lady.
I think that would be helpful to us all, because I mean, it is a whole new aspect.
Yes.
I mean, I wasn't anticipating it, but if it is going to be raised, then you're absolutely right, Ms. Clements, and I'm grateful to you for raising it. So whoever's doing the checklist, we need to include that in the directions.
I'm very grateful. My lady, the only other point, the timetable that was agreed for skeletons was agreed without my involvement.
Yes.
And it falls in the middle of half term. I don't work half terms, so I'd ask for your indulgence to file a week later.
Happy, everyone? Yes, certainly. I think in a childcare case, that's only fair.
That's why I thought I would raise it.
Yes, Mr. Gratian.
Lady, nothing
There you
particularly
are.
that we would seek to add, but I feel like I'm rather heckling from the public gallery, making submissions. We agree with the proposed draft directions with the amendments that Ms. Briggs has proposed.
Excellent. Thank you very much, Mr. Gratian. Right, let's turn then. Do you have any questions? Okay, well, shall we turn then to Re-M? Mr. Montez.
My lady, very little to add. The anonymised judgment in our case was published, I think, yesterday. I'm sorry it hasn't found its way to my lady and my lord, but it has just been sent to my lady's clerk in the Civil Appeals Office. And
Thank you. So we
the
don't need
advocates
that
have
in
had that, I think, this morning or yesterday.
Good.
My lady, just in relation to the directions, again, we take no issue in respect to the proposed directions. I just wanted to just check one matter, and that was in relation to the listing of the 3 or 4 days.
Yes.
I see that my lady proposes that the parents or the clients would not attend that part of the welfare hearing which did not relate to them.
Yes.
Does that also apply to what's being termed as the common issues
No.
Because my client certainly would wish to attend
No,
that part of
absolutely.
the hearing. I just want to clarify that.
No, it is simply to clarify that once we're onto the welfare issues,
Understood.
that then becomes like any other discrete
Yes.
appeal. Which I should say, actually, I should say that technically it will still be an open court. I mean, we're the Court of Appeal, so it'll be an open court. So, in fact, we can't say they cannot be present.
Yes.
What we can say is they're not required to be present.
Yes.
And our understanding is that the strong likelihood is that they will not be. Clearly, because it's an open court, anyone can attend.
And do we have an idea, perhaps not at this stage, what the capacity is going to be? Because it may be that some people may have to attend remotely.
Yes, well, I think that'll have to be in negotiation with listing. I think that's
Well.
our pay grade.
Thank you. Lady, in relation to the bundles, given that we are legally aided and Ms Briggs is not, we have
Yes.
agreed to take carriage of the common issues bundle and
I'm
the
very
authorities
grateful
bundle.
to you. Thank you. Could we make sure that's in the
Yes.
order as well, please?
My lady, in relation to the common
So,
issues...
I'm sorry,
Sorry.
can I just interrupt there?
Yes.
In that case, is it only fair? I'd completely forgotten that Ms Briggs was most of her team. If you're preparing the bundles, would it be more appropriate for your team to have carriage of this order?
May I just turn my back and...
I'm not trying to land the word.
Gatland won't be able to
She's
say no
looking
to that.
sad, I'm sorry. Or do it together. I mean, you know.
Yes.
You walked straight into that.
Yes, I should have thought that before. Yes.
It's either that or you need to ask Mr Wilson, who is, I note, my crib sheet is legally aided.
Lady,
If we're staying with Jay doing it, I mean, work it out between you. But what I'm saying is that please, could someone that is going to get paid have carriage for this?
Yes, of course.
For the drafting of
I'm so sorry. In relation to the common issues, Lady, there may be legal issues which are not common to other appeals, if that makes sense. So, for example, the issue of dishonesty, parental responsibility agreements, applications by step-parents. Although those aren't necessarily common to the other appeals, it may be that submissions might be made in respect to them.
Understood. I mean,
So-
if you want to recategorise it as legal and common issues,
Yes,
that's fine, because, of course, the reason that we're hearing the three together
yes,
is because different cases may throw up different wrinkles that we need. The President is very keen that we deal with all in one go.
Understood.
So we were anticipating, weren't we, that there may be particular legal issues that actually have been thrown up by a particular case, but are not opposite to the others.
Thank you, that's very helpful, my lady. My lady, in relation to transcripts, my lady has already dealt with that. We will include that in the order in terms of some of the oral evidence in our
Yes.
case. In terms of the length of a welfare hearing, I think I speak for all the advocates in our case in saying that we think probably half a day would be sufficient to deal with the welfare issues in our case. I think it's said in another case it may take longer. But if we have 2 days for the common stroke legal issues, half a day for our case, and then...
We thought that was more
Yes,
than comfortable.
very well.
Because, as you rightly say, we'll have been through the legal issues and we'll be focusing on the welfare outcome.
Yes, lady. Lady, I don't believe there's anything else from me unless I can help.
That's
in any
very
other way.
helpful, thank you.
Thank you so much.
Mr Norton.
Lady, I don't think there's anything more from me. We agree the outline by Mr Montez a few moments ago in Brienne and the directions, as my lady's hopefully given us, are agreed. Can I just clarify
Of course.
paragraph 11 and 12?
Yes.
It might entirely be my reading. I just want to be clear so we don't fall into error. Does my lady anticipate that anonymised skeleton arguments are circulated to all parties in the common and legal issues, and that they then may be redacted further for distribution to the press? Or is my lady anticipating unanonymised, as it were, documents? I'm just looking at the wording in paragraph 11 and 12.
I'd anticipated that in the normal way the skeleton arguments filed, which go to all the parties, and in this case all the co-joint appeals, would not be redacted. But then I was really trying to address the issues of the press so that you don't all find yourself in that awful position of 12 hours before the hearing. We've got, quite rightly, there's going to be considerable press interest in this,
Yes.
that the press are saying where are our anonymised copies. So I was trying to look ahead. Do people have strong views? Do you think it's not appropriate for? Would you prefer your anonymised versions to go to all the parties and only the court have the unredacted versions.
Can I just check, my lady, whether we are using the anonymised and redacted,
Well, exactly what I
whether they
don't
are the
want.
same or that they are
we
different?
we do not want anything with a black line on it.
Right, yes. So we can do an anonymised document, but we might provide some black line elements to the document that we then provide to the press. Yes.
Yeah, but please do not let us face emails from the press saying, what use is this?
Yes.
There's nothing left in, which is why I've put that rather irritating minimal reduction only as necessary to
Yes.
avoid jigsaw. You know, we're going to have enough to do without, and it's really important that we are seen, that the press see that we are engaged with them. We know that they're going to be very interested in this case. It's a very important case, and so we must make sure that they get proper access to the information before we start hearing it.
So anyway, nothing more from me then.
Excellent, thank you, Mr. Norton. So, Mr. Maynard. Yes, Mr. Maynard.
My lady, can I apologise for the absence of Mr. Rowley of King's Counsel today due to public duty? We are extremely grateful for the work that's been put in on behalf of the new parties, and we agree entirely with the way that's been outlined by Mr. Montaz as far as King's Counsel, as far as our appeal is concerned. We're grateful to your ladyship for grasping the nettle of transcripts today, which is welcomed on our case, and we concur entirely that half a day is adequate insofar as the welfare issues in our case are concerned.
Good. Excellent. Thank you, Mr. Maynard.
Thank you very much indeed.
Anything else on the M?
So what did you say?
Are you happy on the M?
Yes.
Nothing else you
No,
want to add?
no, I've only got one thing which comes to me.
Okay. Yes, Miss Markham.
My lady, my lord, and may I start at the top of your document, my lady, in terms of the way in which repeat cases identified, and query whether the last two words need to remain in at this point in time. I'm not saying them for obvious reasons. The name.
Well, Miss Markham, I understand why you're being coy, but that
Yeah.
information is going to be in the public
Well-
domain and be referred to throughout the hearing.
Well,
It's
my lady,
critical to your get to the case.
it is, my lady, but I've been asked to flag it, and I'm flagging it at this point in time. As to paragraph 4,
Yes,
we understood that they were going to intervene in relation to the legal issues only.
yes, that's right, and I think that was...
Common and legal.
Yes,
Just to
thank you.
clarify.
Yes, it's now common and legal, we're referring to it.
Thank you. May I attempt to persuade my lord and my lady on our case, on the welfare issues, to give us slightly more pages to deal with the welfare matters in the skeleton argument, and that may then impact on the timing in court that is needed. We already have the issue, of course, on the particular issues in our case as to matters that may necessitate a longer time in court, but if there are slightly longer pages allowed for dealing with documentation that way, it may well be that we can deal with the oral submissions in the half a day.
I think you'll have to be a little less Delphic.
Well, because of the need for interpreters, we may need breaks, and half a day may not be
I understand
necessary.
that, and I think we'd both
Yes,
taken that into account. When we incorrectly thought J
yes.
had welfare issues, that's why we had put you last on day, what was going to be day
So
4,
we could-
so that if you tipped in,
Yes.
we could deal with it. But now it looks like we're back to 3 days, doesn't it?
Yes.
So you think if you're allowed to have a longer skeleton argument,
Well, there will be
Yeah.
less to say then, because we will have put it in writing, and then our clients will know what's there, and therefore we believe that it would assist their participation to deal with it in that way. Yes, 8 or 10 pages.
oh well, I'm not going to fight you for that, Miss
No.
Martin.
They were telling me to tell you how many.
And I don't think anyone else is going to feel badly done to, or at least Re-M's not going to feel badly done to.
So it was balancing the length
Understood.
against the time.
Understood. No, that's helpful, and certainly.
In terms of participation, because of the jigsaw identity and the actual identity, because it's open court, is there any possibility in this case that the parties can attend remotely?
So you want to see VP?
Yes.
No, only your lay clients.
the lay clients in REPI.
Yes. Yeah, I think that seems sensible.
I'm grateful.
No one's got any
For-
objections.
Just for the welfare issues.
No, it would be throughout because of the.
Well, we are not having stopping for 10 minutes at every hour during the legal argument.
No, I'm not asking for that, but for permission, if they want to participate and engage in the court process, that they can do so in the common and legal issues by attending remotely, but they would not be afforded the same participation with breaks as they would in the welfare. We understand that.
Yeah, that's fine.
Thank you. I don't think there were any other matters then that I wanted to deal with. May I say, though, however, that, and we are grateful to Ms Briggs, when King's Counsel, when you say to try the issue, she did take the lead, she did send material out, she has very much taken the lead on this case, and I think it's right that she is recognised and her team for doing that. On behalf of REPI, we are almost now at one in relation to the issues that we say are before.
Well, I'm sure that would be a big relief to Ms Briggs.
Yes.
She's trying to put it all together.
Okay.
Can I just ask you about a couple of things I wanted to ask you specifically,
Yes.
please, Ms Markham. First of all, in your note, for which thank you, on interpretation, you refer to the possibility of using capturing the editing so that you have simultaneous transcription.
That's in fact my learning friend, Ms Basie, King's Counsel, that's dealing with that. It's her note.
Fine, of course it is. Well, I'll come to her about that. So, anything else from you, Ms Markham?
No, I don't think so, my lady, my lord, unless there's anything else I can assist you with.
No, that's really helpful. Thank you very much. Yes, Mr Page.
My lady, as you can imagine, there's been a huge amount of extremely constructive discussion and agreement between all the parties.
Yep.
And I want to join with my learned friend in tribute paid to my friend Miss Briggs for organising all that. We have gone through all of the issues that I wanted to raise on behalf of the children in relation to this appeal this morning, and more than content with the way that those matters have been resolved by the court this morning. The one discrete issue which we left in our position statement was the hangover in relation to the permission to the appeal application made on behalf of the child.
Yes, of course.
And we know why it's arisen in the way that it has. It's because of the sequencing of the filing of the relevant documents. Because we as a legally aided party were hampered by the catastrophe which befell the legal aid agency.
Oh.
So in the first few weeks, nothing was simply going through. So as soon as permission were granted by the legal aid agency and funding came, I think it was almost on the same day that our application, which had been waiting to be filed for several weeks, was filed. The other point that we make is that the single ground of appeal that we raise is in fact had been the subject of permission granted by Mr Justice Poole when the matter came before him under Part 30.
Yes.
And so there is an almost identical overlap. So I wouldn't have thought, I don't think there's any opposition to that formally being reflected in an order so that the formalities are dealt with in that way. And that we can simply proceed on the basis that we are a second appellant and the permission stage does not need to be addressed any further in any of the submissions made to this court.
Yes, I'm just looking at your proposed draft ground appeal, which is in your position statement.
It's the last paragraph.
22, yes, I have it. Does this add to any of where we're going to be on the common issues? Is this a new legal argument?
It was a legal argument ventilated in the court below and the subject of a ruling by the learned judge as to the issue as to whether or not the court had the statutory power to make a declaration of non-parentage in the...
But isn't that going to be one of our common issues, legal arguments, whether the statutory interpretation of Section 55A?
I haven't read that it is, which is why we've left it as a slightly to one side. It has been the subject of permission granted to learned friends in their first appeal. It was ground 3, I think, so Mr Justice did grant that. So in those circumstances, we rather took the view that if the court were minded to consider the overall statutory framework, including the court's powers, in relation to making declarations of parentage in the unique circumstances of our case, then that should be a matter that should be considered in the round on an appeal. We've addressed it in our permission to appeal skeleton argument. As a fallback position, because the learned judge took the view that she could not hold that the terms of the draft that we put before her could be the subject of a statutory declaration. There was no opportunity actually in the court below to argue as to whether or not it fell within the proper exercise of the inherent jurisdiction to make a declaration of that nature.
All right.
So that broadened the appeal slightly to the issues raised in the court below, because there was effectively no challenge to the submissions made by the other parties in the court below, and it didn't arise during the course of exchanges with the learned judge during the course of oral submissions at the conclusion of the hearing. So it's there. It is a single ground of appeal that we advanced, and we would respectfully invite the court to grant permission on that ground so that we can address it. I think discreetly in our appeal, though of course it may well be the Secretary of State has a view to take on that because it involves a question of statutory interpretation.
Thank you. Yes, we'll give permission.
Extremely brief. There's nothing that I'd seek further to add to what you've already heard this morning.
Thank you very much. Now, Ms. McKenna, we've slightly taken out of order, taken the Guardian before you, but
because, my lady, the Guardian is an appellant.
Of course.
And, my lord, on behalf of the mother, we don't advance any grounds of appeal. Counsel, in the first instance, was refused at the matter. We as a team are recently instructed.
Yes.
The manner in which you've put structure to this cumbersome collection of advocates is endorsed by all of us. So, there is the draft order as amended and discussed with previous counsel, accepted on the mother's behalf in REP. We will work hard to ensure that our skeleton argument, when it's due, is shared and perhaps may not need to exhaust our time limit in terms of the common issues. Our page limit if we're going to be adopting and falling in behind the position of others. But we'll make that clear on any document that we submit.
That's very helpful. Thank you very much. Yes, yes, the 20 pages is not a target.
We will take that approach.
Thank you very much.
In respect of the mechanics that you will hear from Ms. Baisley regarding in terms of the interpretation, they are problems or challenges that apply to all of us in this case.
Of course.
But I won't, on this occasion, cause you to hear it twice.
Thank you very much, Ms. McKenna. Yes, Ms. Baisley.
Thank you, my lady, my lord. May I deal first with the issue of attendance by the lay parties at the welfare hearing in our case? Our client has given instructions that he would like to attend in person. And I think the court had anticipated that lay parties would attend that part of the hearing in person.
Well, anticipated they might wish to, yes.
Yes, which of course gives rise to the need for interpretation during that part of the hearing. And I do have to express some concern about a half-day time estimate for that welfare part of the hearing in REP, and wonder whether the court might keep the fourth day, for now at least, in case it's needed.
What are you thinking about?
So sorry, Anne.
Not at all. I think we'd like to hear a bit more about what you're saying the structure should be for the welfare.
Yes. Well,
hearing.
we are receiving fresh instructions, in fact, now.
Yeah.
This may not be an issue. I wonder if I might turn my back
Please
for
do,
a
Miss
moment
Paisley.
and just make sure I'm...
No, we're very happy to hear your submissions, and if you need to take instructions,
Thank you very
please
much.
do.
No, that issue has gone away in the course of the hearing, so I'm grateful.
So just
He will be content with the
CPV.
CVP, yes.
So let me ask you the question arising from your helpful note
Yes.
about simultaneous transcription. Is that something that you think that you could receive the funding for and would, on behalf of your lay client, ask the court to approve?
We have no funding. Our client appeared in person below.
Yes.
We are acting pro bono
I
in
see
the
that.
appeal. But our instructing solicitors have done some research and believe that they may have access to the technology. So it's not a funding issue, it's merely whether the court would sanction that as not being any form of recording and
We would not. We had your note, so we've had an opportunity of discussing this.
Yes.
And we wouldn't, and we'd be prepared to sanction it. But you do realise that every party would have to have copies.
Of course.
You wouldn't be able to.
No.
Your lay clients would have to understand that everyone would then have the advantage of the transcription, which would have to be made available at the end of every day.
Yes. I believe it's simply a question of pressing a button, and it's quite easy to do.
Marvellous.
Thank
Yes,
you.
well-
And if the
well-
court wished to have it, we would of course.
Of course we would. Yes.
Yes.
It would be.
Yeah.
Yes, please.
Thank you. May I just then, if I
Sorry,
may,
just go back to Ms Briggs for a moment.
So sorry.
Because, so if we can include in the directions
Yes, my lady.
that the permission's given for the transcription and that it's to be provided to all parties and to the court at the conclusion of each court day.
Yes.
Thank you. Sorry, Miss Paisley.
Thank you, my lady. My lady, the only other point from me, we agree with everything that's been said already, is the final sentence in my lady's draft order. The position is this, that interpretation comes from an HMCTS fund.
I know.
And so it has happened in many other cases that the court understands the difficulty of having conferences and consultations with a client who requires interpretation outside the court hearing. And certainly in the High Court and below, what happens fairly routinely is that the court permits a sitting day to be listed with no attendance on the basis that the interpreter will go to the solicitor's office and assist at a conference. And that's what we're asking for.
I know, but I think we're feeling distinctly nervous about that in the Court of Appeal. Ms Paisley, I do very much appreciate the challenges of taking instructions, and
Yes.
I very much appreciate the fact that you're pro bono and the funding would be available through HMCTS. What subject to my Lord's view? Ms Paisley, we'd like to be helpful, but we don't have any submissions, and this is not a criticism as to our powers or how that works. We think the sensible thing would be for you to make effectively a freestanding application to the masters,
Yes.
who in turn can refer it to us to consider it, and that gives you the opportunity of finding out, doing a bit more research
Yes.
about how it could work and how it does work.
Thank you, my lady.
For
That's
them to
understood.
consider. Does that
Yes,
work? Do you
I'm
think?
sorry you didn't have the research done
I'm,
before
I'm,
today.
you're pro bono. We're just very glad you're here.
Thank you. Oh, I think Miss McKenna has something
Yes,
she
Miss
would like
McKenna.
to say.
sorry to bob up again,
That's all right.
my lady, but the issue of interpretation is a challenge, as you've indicated, and it would help enormously if those instructing me could liaise with your court staff to test the technical arrangements that would be in place for the CDP with our interpreters on a date that's convenient to the court and to our team in September, October.
That would normally happen.
Thank you.
That facility will, as a matter of course, be arranged. But you'll just have to make it clear with listing and the court that it's to be arranged on a day when the interpreters can be available.
We're not entirely clear about how many people would be likely to turn up, because there'll be all or some of present company, plus some clients and so on and so forth. And so it would be helpful and probably essential if by a week before we could be told effectively what the maximum numbers are, because we may have to apply for a bigger court. It is even possible that we may have to apply for a court that's in the Rolls building. So could that be done? Between you?
You have a contact list, I believe I've seen in your hand. If we update that with who is coming,
yes,
then the maths can be...
Yes. Really, all we need is maximum numbers, counsel, supporting lawyers, clients, total equals.
Certainly.
But I don't know who prepared the chart for us, but it's been absolutely invaluable, and so if we could keep that
my junior, Mr. Landerman, put his mind to it.
Well, I'm very grateful.
It will need updating, but yes.
I'm very grateful to him. Thank you. Thank you, Mr. Landman. Miss Briggs.
Lady.
I think that we're nearly there.
I think we are.
As part of the directions, it says that REJ is to be the lead case. We also identify you as lead counsel, as everything, as you seem to be being the noble conduit through which everything is passing. So we're very grateful. I mean, I appreciate how much work is involved.
It's a team effort, and we're very grateful to the agreements that have been reached in respect to condols and all other manner of things distinguished in the case.
Now, Ms. Briggs, we are, and my Lord's reminded me, of course, that you are pro bono in this.
Yes.
I do. I'm aware you have to earn a living as well as not just living this case between now and November. I mean, if between you feel that M would be more properly, or someone else should be the lead counsel that is actually going to be paid for their work, we are completely content with that. And we don't want to overburden you or your team or anyone who's acting pro bono.
Lady, yes, well...
And it can't be P. It can't be the lead case because of its idiosyncratic aspects, and we want to make sure that we have they go last so that we can manage interpretation and all the rest of it for them.
Yes.
So can I ask you to work out between you? But I emphasise, we both emphasise, my Lord raised it particularly with me just now, that
yes.
you must not feel that you are to carry too much of the burden of this.
Lady, I'm most grateful. That is appreciated. Two final points,
yes.
if I may. The first is we were considering the question of seating arrangements at the
yes.
appeal hearing. Might it be better if we identify the numbers by 14 days in advance, and then we can, if movements are made to find an alternative court, then perhaps our juniors can
go and
come
have a
into
look.
court one day, have a look, and make the seating arrangements.
That's a good idea. Excellent idea.
And then might we request a soft copy copy of the proposed directions so that we can use that as a starting point for the order that we will
Yes, certainly. Can't have mine, I'm afraid. It's scribbled all over it.
An electronic.
Oh, sorry, beg your pardon. Yes, you've got a hard copy. You want a soft copy? Yes. Oh, did you not get sent it? Oh, you were just. It was just handed out.
Yeah.
Fine. Of course you may. Does everyone want it in that form? Yep, of course. It's nearly the end of term. Now, just one other thing went through my mind, only to exit by the other ear. Provide for an advocates meeting.
Yes.
No, it's gone. No doubt. If it's hugely relevant, when I get a draft, I'll think about it.
I've been taking notes as I've gone along, my lady, and there were two issues I think that you raised that you arrived at further to handing down the hard copy of this document. I made a note of both of them. I can't tell which they are in my notes yet.
No, that's fine. The registrar. So we may
Yes.
have another, but at the moment, again, we'll see whether the registrar wants to join.
Yes.
But my feeling at the moment, we had a chance to discuss this before we came into court, that if the registrar intervenes and if we permitted the other potential to intervene, they'd both be written only. Wouldn't be looking to oral submissions for any more interveners.
No. Fair enough.
So you needn't concern yourselves that you're going to have to fit into the oral submissions potentially 2 more people.
Thank you.
I've sent it to you.
Oh, thank you. Well done. Could you distribute it to everyone else?
I shall. Yes.
I think I've sent it to you.
At least you know the difference between hard and soft. Now, anything else that we can usefully do? Well, can I say I'm very grateful to all of you. This is an important case, and to see the way council are working together to ensure that we have the most effective and efficient hearing of this difficult and very significant case is extremely valuable, and we're both very grateful.